Hi, I'm John Evangelakis. I'm the president of Harvard Alumni for Free Speech, and I'm here today with Phil Auguste in one of our continuing reports on the Harvard's litigation against the U.S. government over the suspension of over $2 billion in federal grants. Just as a reminder, Harvard Alumni for Free Speech is a nonpartisan, nonprofit, independent group of alumni dedicated to promoting and protecting free speech, academic freedom, and viewpoint diversity within the greater Harvard Radcliffe community. So with that, why don't we get into the discussion? I think based on our prior recordings and also based on what you've been reading, Harvard sued the federal government some months back. There was a hearing in July, and this past week, just a couple of days ago, Judge Burroughs in the District Court of Massachusetts issued her decision. And Phil, why don't you've been through it, let's give our audience an overview of what she came up with.
Sure, John. Basically, the court found that there were violations of the Constitution in what the government did in terminating Harvard's contracts or Harvard's grants. And essentially, the court walked through the letter that it sent to Harvard on April 11, making a series of demands that had to do with Harvard changing the nature of the viewpoint balance, if you will, at the university, and trying to get a more conservative mass at the university. And she walked through the almost immediate freezing of the grants, all the grants at Harvard, and then a bit later, the termination of those grants. She decided that based upon the facts that were in front of her, the document, the administrative record, which is the documents that reflect all this, that the government had essentially unconstitutionally tried to compel Harvard to change its point of view and had punished it, withheld benefits from it as a result of Harvard's refusal to do that. This was a violation, she found, of Harvard's rights under the First Amendment. She also found that a certain law called Title VI, under which the government can terminate grants for discrimination, had the procedures that are required for that law to come into effect were not observed. And that some of the rationales given for the primarily the anti-Semitism rationale didn't really have any backing based upon her review of the documents. That's to say that the administration had taken the action without really looking into whether there was, in fact, an anti-Semitism problem, and did not make an effort to see that the remedy that it took against Harvard, terminating its grants, would contribute in any way to ending anti-Semitism. So basically, Harvard, on the merits of the decision, did have a pretty resounding win. I should add that there's something called the Administrative Procedure Act that the judge also found wasn't followed. The bigger question, I think, is going to be, as this case goes up on appeal, is whether the case was heard in the right court. The United States can only be sued for damages in the Court of Federal Claims. That's under a statute laid out by Congress. Congress only gives the right to hear those cases to that Court of Federal Claims in Washington, D.C. And of course, this claim was heard in the U.S. District Court for the District of Massachusetts. Harvard has argued that it isn't looking for damages, but of course, the government's taken the position that really what this is an attempt to try to get the government to pay it money. And so therefore, this really belongs in the Court of Federal Claims. If you look at this, I should say, is kind of an area of the law that has been very relevant in 2025 as a lot of grants are being terminated. And there's been two cases by the Supreme Court on these sorts of cases. The most recent one is an APHA case in which Justice Amy Coney Barrett found that when you're talking about termination of grants, that's really supposed to be in the Court of Federal Claims. Forward-looking relief, like an injunction, is something that the U.S. district courts can do. But and given what happened here, the court found, first of all, that the contracts had been improperly terminated and tried to get those restored, and then it had an injunction against doing a similar act in the future. The most important part from the perspective of getting money is the part that restores the grants. And that, it would seem, looking at the APHA case, might well belong in the Court of Federal Claims. The forward-looking, the injunction that the court granted against future violations would seem under Justice Barrett's reasoning to properly end up in the U.S. District Court. But just to say that while on the merits, Harvard does seem to have a significant win on the jurisdictional issue, the issue of which court does this belong in. It does face a problem, and of course, if the Supreme Court or the First Circuit, the Court of Appeals that reviews cases from the District of Massachusetts, decide that really you need to file those grant restoration cases in the Court of Federal Claims, Harvard will have to start all over in the Court of Federal Claims to try to get that relief. So that's what I would say for right now, is just an overview, John, and I'm very interested in any thoughts that you might have.
Well, thank you for that excellent summary. Actually, the first thing I just want to do is, I think you and I, we're kind of, we're lawyers, we get into all this, but just to maybe provide a little more detail and flavor, and, correct me if I get this wrong. The case you're referring to, the APHA case, is American Public Health Association versus the National Institute of Health. It's an interesting case that came up. It was actually not appealed. It was on a motion to suspend the lower court's injunction. And now Phil is technically correct. It was Justice Barrett who's the decider, but it was actually the Supreme Court split 5-4, with Justice Barrett being the pivotal vote. So, in that situation, her reasoning is actually the reasoning of the court for this purpose. And I think, Phil, if I have it right, what she said in that case was that it was a preliminary view. And I stress preliminary because I think this is still an evolving area, the suspension of the grants in that case probably belonged in the Court of Federal Claims. So, I think that's just, I guess the question is still open. But even before we get to that, though, Phil, there is still the question of what happens on appeal, right? So currently, Judge Burroughs, the district court judge, has issued her injunction. Under the terms of that injunction, the federal government's supposed to begin paying out these grants. If the federal government hasn't already, they very soon will be seeking a stay, which is a suspension of her injunction. And that's going to go first to the First Circuit. And if they don't suspend that judgment, then it's going to go up to the Supreme Court on a case that looks, very on, the legal, in terms of the facts, seems to be very similar to what's going on in this case. I don't know, Phil, maybe you disagree, or I just try to sort of give it some more flavor and some more texture.
No, I agree fully that I think that we might see a lot of action here in the next few days because I actually would anticipate that it's Friday and I anticipate that before the end of the day, the government will probably move for a stay on continuing payments. It could happen on Monday morning, but very soon it's going to happen. I think that it's more likely than not that Judge Burroughs will deny that that motion for a suspension of her order. Then it goes immediately to the First Circuit, and the First Circuit will either suspend her order or not. And if it doesn't, then it immediately goes to the Supreme Court on what is now is very notorious emergency docket. And then we would have a decision on this issue before the end of September. Now, as to Judge Barrett's view being preliminary, yes, it certainly is preliminary. She was ruling on a suspension of the judgment, not on the merits of the appeal. But she wrote a fairly long opinion about it and was fairly firm in her views. And it seems a bit improbable that she would change her views in less than a month. So I do think that on this very important question of what court this case belongs in, I think Harvard has a few things to worry about right now.
So Phil, let me disagree with you a little bit on that. I think in the American Public Health Association case, the APHA case, she clearly suspended the injunction, the judgment there, largely because there was what she regarded as a risk of irreparable harm to the government, that the money would get paid out and that the recipients would be unable to repay the money. So I think I think that's settled. She decided that issue. And I think this is something that you and I wrote about, I think a couple of weeks ago, a short blurb that was out in our Harvard Alumni for Free Speech newsletter. Harvard here is in fact saying that the exact opposite, which is that they can't actually repay the money and they need the money. So it seems to fall squarely within Justice Barrett's reasoning for why the judgment should be suspended. I actually think in the American Public Health Association case, I think it was unnecessary for her to make her remarks known about the Tucker Act and the jurisdiction case, because I don't think she needed to reach that. So when she says it's a preliminary review, I'm inclined to believe that in fact it is a preliminary view and that it's possible that her mind could be swayed.
I'm certainly not questioning Justice Barrett's credibility on that it's a preliminary view, and she quite properly qualified her opinion in that way. There are two opinions, actually. There's a per curiam opinion, which says quite what you say that it does, which is that it uses the principal ground as the inability of the plaintiffs in that case to be able to repay the government the grant. And so I agree with you that that reasoning would be equally applicable here. But she also wrote a separate opinion that quite squarely addressed the Tucker Act, in detail, and disagreed in detail with the position of the four dissenters that the grant restoration case and part of those cases should be in the district court. And so that's why I think that there is something to worry about here for Harvard. Having said that, my gosh, I'm certainly not saying there's no hope in the court, in the Supreme Court. I think that quite clearly, Justice Barrett could very well change her mind. And certainly, I think that Judge Burroughs wrote at great length in her opinion, in a way to be as persuasive as possible to Justice Barrett.
And Phil, maybe we should I think this is now our third recording on this, and I know we touched on it in at least the first one, maybe I think the second one, actually not the second one, the first one. The consequence of having the case reheard is just to remind our viewers, right? Essentially Harvard has to begin that part of the case, basically unfreezing or unsuspending the current grants all over again in another court, the Court of Federal Claims in Washington. And I think also then that there would be two separate actions, one on the forward-looking grants and one on the existing grants. And yeah,
Yes,
and then
I'm
yeah,
sorry.
and then without getting too much into the weeds, I think there's also some issue regarding whether both cases could proceed at the same time, just to further complicate the situation. So and I guess the other thing, just to remind viewers, if in the Court of Federal Claims, if Harvard were to be successful, they would not get any money until the very, very end, which means after a judgment in the Court of Federal Claims and appeals all the way up to through the Federal Circuit and possibly the Supreme Court.
That's exactly right. The principal downside for Harvard of being in the Court of Federal Claims, and I suspect that the reason why Harvard filed in the U.S. District Court and pleaded its case as it did is because it's clear that when you sue in the Court of Federal Claims under the Tucker Act, you are not going to get any money until the litigation is completely finished.
So this is a situation where Harvard could actually find itself, prevailing on the merits, but essentially, losing because of the procedural posture and jurisdictional requirements of the case. So we'll see.
It wouldn't, just to be fair, I don't think it would be a complete loss. What they would have to do is they would have to re-argue the case in the Court of Federal Claims. Of course, it's a complete loss in terms of timing because it would be a very long time. Let me say one other thing about the merits that I neglected to say when I kind of summarized everything, which is that it was a resounding victory for Harvard on the merits. And as I said, Judge Burroughs' opinion on the finding of constitutional violations was very thorough and seemed more or less well-founded. But one of the things that she pointed out is that unlike in a trial where the judge or the jury make findings of fact that courts of appeal then have to respect and defer to, this is not that kind of a case. This is a case where the court just reads documents. And that means that her reading of the documents is not entitled to any legal deference. So Harvard has to sort of fight it all over again, if you will, in the First Circuit, and then, of course, in the Supreme Court, if it gets to the merits. So if the Supreme Court finds that this thing occurred in the wrong court, the Supreme Court won't get to the merits. It'll just send it back to be litigated in another court. But if it does come to the Supreme Court has a right to review the documents on its own all over again, sort of as if Judge Burroughs hadn't looked at it, and then reach its own conclusions as to whether there were constitutional violations.
That's an important observation. Thanks for bringing that up. I think just in our last few minutes here, Phil, why don't we pivot to the other part of the case, which is the forward-looking grants, and there's I think a great victory for Harvard, but maybe a Pyrrhic victory as well. So clearly the injunction, Judge Burroughs' injunction, applied as well to future grants of for the federal government. They could not use the threat of withholding grants to violate the First Amendment or violate Title VI, or pretext, etc. But I think that runs squarely into the issue of how Harvard is going to be able to enforce that. And maybe you can explain that to our viewers.
Sure. It's clear from Judge Burroughs' injunction, forward-looking injunction, which, by the way, I think has based on Judge Barrett's uh, most recent APHA decision, which, as you know, assuming that it stays the same, that would have a pretty good chance of being upheld, which is to say, not being suspended, and it would be immediately in effect. Um, the difficulty, of course, is that the government has a lot of discretion in who it decides to give a grant to. And unless the government were to do something, kind of foolish, like writing to Harvard that it's not going to give it any grants because of these things that it's enjoined uh, from not doing, it can just, as a matter of discretion, decide not to give grants to Harvard. And it would be difficult for Harvard, certainly not impossible, but it would be difficult for Harvard to prove in a given situation that the government has decided to give a grant to, say, Columbia University because of this forbidden reason instead of for a bona fide reason.
Yeah.
So it is the injunction, while it is a great victory for Harvard, uh, enforcing the injunction down the road might be something that is a little difficult to do.
Right. Yeah, no, and I think the White House, perhaps not following Phil's advice, has already said that they're not, that they're, I think, not going to be looking to make new grants to Harvard. Not sure I would have advised them that to make the statement quite so strongly, but that seems to be where they're going. So, all in all, I think great victory for Harvard on the merits, at least before Judge Burroughs. A lot of questions regarding jurisdiction and the procedural process of the case. And I think looks like we're going to be seeing a fair amount of action, legal action, within the next week in possibly several courts.
I think that's right.
Yeah. So I think that's it. I don't think we have any, I don't think there's anything else for us to cover at this point. So we're going to continue, Phil and I are going to continue monitoring this space, this situation, and we will continue reporting on, on developments as they arise. Thank you very much for joining us. Phil Augusti, John Evangelakis, brought to you by Harvard Alumni for Free Speech. Thank you very much.
Thank you.